Welcome again to the best Florida family law podcast. This is attorney Jonathan Jacobs of the Jacobs Law Firm. I'm so glad to be here with you today to talk about one of the top issues, one of the most important issues in all family law cases involving minor children. Which parent, or both, will have school designation and enrollment authority? Let's make a very clear distinction. Having shared parental responsibility over academic decisions is not always the same thing as having school designation and enrollment authority. Academic issues such as having an IEP, having a specific plan for performance, extra time to take tests, tutoring, after school care, things of this nature relating to academics, those are academic decisions. Go to AP class, go to regular classes, maybe take dual enrollment. Those are academic decisions. School designation and enrollment authority is often based upon a person's address. Where do you live? What public school district are you zoned for? Suppose, in a mythical world and a hypothetical case, mom number one and dad number one live within 5 minutes of each other. They have a paternity case, and the court orders that mom has school designation authority and that she is the one that can decide where the minor child goes to school. Now, this is based upon her current address. But then suppose mom leaves that school district. She moves 20, 30, 40, all the way up to 49.9 miles away. Then what happens? If your case has school designation enrollment authority for mom number one, essentially permanently, wherever she moves, she generally will make that decision. If either or both parties move from that school district and the minor child is no longer essentially zoned for that public school district, then we may have a problem. Because if dad doesn't have the authority, then he might have to transport that minor child an hour away every day during his overnight time sharing with that minor child. Or the minor child may have to go to a school that's a private school with a scholarship, if the parents can obtain one, of course. That is few and far between, but it is also possible to get enrollment at a place like a charter school. These things do happen. Life happens. Career changes happen. Moves happen. All of these things are just part of daily life for almost all of us. Shifting jobs, shifting housing, different careers, different life circumstances. Let's take a different example. Dad has school designation authority after a divorce with 2 minor children. But what happens? Dad has to move away to another state. Now it becomes a long-distance time-sharing plan or a relocation case. Suppose that dad now leaves the children a majority of the time with mom number 2. So dad 2 is now out of state. Mom 2 now has school district authority to enroll the minor children wherever she is districted for based upon her current address. Let's choose a different example. 2 parents are divorced from each other. Both parents have school designation and enrollment authority. However, neither one can agree. One parent wants a Catholic or a Christian school on scholarship. The other parent thinks that the local public school is in the minor child's best interest with a better academic program, better reading proficiency, what have you. What then happens if the 2 parents cannot agree? Well, what usually happens is an emergency hearing in July or August if you can get court time. But in a reasonable circumstances, what would happen? The kids finish school in May, and then the parents confer in June. They cannot have a decision, so they schedule a hearing a month or 2 later. At that hearing, both parties, mom number 3 and dad number 3, are likely to present to the court information about each one of those schools. And in this podcast, I am not going to give you legal advice ever. And I'm certainly not going to tell you how to seek to enter evidence into the court record during your hearing, but I will say be very, very careful how you intend to do that in your sources, because this sort of a hearing in the best interest of the minor child for wherever they will go to school, your burden of proof and burden for entering evidence may be a little bit different than you are normally accustomed to, even some of the lawyers out there. Having said that, both parties will present information such as school rankings, class size, teacher to student ratios, extracurricular activities, national test scores, graduation rates if this is a high school, so on and so forth. Ultimately, school designation and enrollment authority should be decided in your parenting plan. If it is not, of course, that creates a huge vacuum in a situation that the court may have overlooked or you have overlooked. But you may need to go back and litigate the issue. For the moment, consider carefully how you're going to do this. A middle-of-the-road solution is both parties must agree. But that almost guarantees a court action if one of those parties moves away because they do not want their child or children to remain 20 minutes away, 30 minutes away, 40 minutes away. They would rather have the other parent make that drive or just completely reform that time-sharing parenting plan schedule in a way that might not be mutually agreeable. Please work together, not only with your counsel, but with the other parent in the best way you possibly can. Not thinking necessarily just about your work schedule, not thinking necessarily just about your own needs, not necessarily thinking just about how you feel about the other party, but based upon what is in your child's best interest. That is the pole star. That is our guiding light in family law cases, and that is, in my opinion, the court's first priority in all of this. This has been the Best Florida Family Law Podcast from Attorney Jonathan Jacobs of the Jacobs Law Firm. Nothing we've said here today is legal advice. These are strictly hypotheticals for your reference and so that you can learn a little bit more about how family law works. Thank you so much for joining us.